You're watching Education for Health Professional Regulators of Ontario, colleges under the Regulated Health Professions Act. Richard Steinica is a senior partner of Steinica Mikura LeBlanc, and he practices exclusively in the area of professional regulation. Richard is a noted author of the Complete Guide to the Regulated Health Professions Act, which, because of its comprehensive nature, has been cited by courts and tribunals, even in cases dealing with non-health professions. Marshall Molesky is the past president of the Federation of Health Regulatory Colleges of Ontario, and he serves as Chief Executive Officer and Registrar of the Ontario College of Pharmacists. Join Marshall and Richard now as Marshall poses a number of important questions on behalf of those of us who want to know more about regulating healthcare practitioners in Ontario.
This presentation is aimed particularly at new council and committee members, and it will also be helpful to new staff. And we're going to cover 5 main topics. The first topic is foundational concepts, things like the social contract and what's the public interest and accountability. The second series of topics will be about fiduciary duties, confidentiality, conflict of interest, diligence, those kinds of things. Then we're going to talk about governance, which is the roles and responsibilities of the various actors or players or participants in the regulatory process, such as the council, the committees, the registrar. Then we're going to look at core regulatory activities of the college, things like restrictive regulation and reactive regulation and proactive regulation and transparent regulation. And then we're going to have a number of specific topics, duties and functions of the college, things like how we would deal with equity issues and how we will be more transparent.
So Richard, in our society, governments have the ultimate responsibility for regulating dangerous activities. What options do governments have in deciding how to regulate an activity?
Well, governments have a number of choices about how to regulate a profession or an activity. First of all, there's always the choice of no regulation at all. And so for many occupations and professions like estheticians, it's consumer beware. They choose and they're responsible for their choice, and they have to work out any problems with the practitioner. There's also another model, consumer protection model. For example, that's often used for fitness centers. So government will make certain rules that fitness centers have to make, certain disclosure, there has to be a cooling off period, there's a maximum term to the contract. And if there's a problem, the consumer can then take that issue to court and it will enforce the consumer protection rules. A third option is that government can directly regulate the activity. And so for laboratories, for example, there is a ministry with certain staff in the department who will oversee and inspect and deal with issues arising for laboratories. The fourth model is self-regulation. That's the one we're going to be talking about today, involving the Regulated Health Professions Act and the 26 colleges under that act.
So tell us about the social contract.
Social contract is a notion that has evolved to describe what self-regulation really is. Self-regulation really amounts to an agreement between society and the profession. Society is going to grant to the profession certain things. They're going to give them a title that only they can use. There's certainly a status that comes from being a regulated profession. And there's certain things that only members of a profession can do that others can't, a kind of monopoly over certain activities that are harmful to the public. In return for being given these things, the profession has to agree that it will regulate itself and its members in the public interest. And so they take on that responsibility.
So what's meant by that term, self-regulation?
Self-regulation is where the profession chooses the majority of the members of the regulatory body who's going to govern them. Typically, these members of the profession form a majority on the council or board of directors. of the college, and they typically also form the majority of members on every committee of the regulator. Secondly, self-regulation involves the governing body that has a majority of members of the profession making the rules and then enforcing the rules through the committee. So they both make and enforce the rules. Thirdly, the profession is consulted regularly whenever rules are made or guidance is given, a standard of practice is published. The profession is consulted to ensure that it fits the practical realities of the profession. As a consequence of this, professions have to pay the costs of regulating themselves. This is not something that comes out of taxpayer dollars.
Since the government has so many regulatory choices, why would it choose the option of self-regulation for a profession?
Well, there's a number of things that self-regulation does that is very helpful. First of all, when you have members of the profession involved in making and enforcing the rules, you have that expertise and specialized knowledge to draw upon. So, for example, if a patient were to be experiencing pain and the concern was the pain caused by the practitioner not acting appropriately, or was the pain just a natural consequence of the treatment, that's something that members of the profession can bring expertise to and give a reasonable decision on. Secondly, regulation only works if there's a general acceptance within the profession that the regulation is fair and appropriate. And so you get a much higher buy-in by the profession when they choose the people who will be regulating them. And in fact, regulation only works when members of the profession participate in it. So for example, the quality assurance program of colleges have peer assessments, and you need to be able to find peers to do those assessments, and only if the profession generally accepts the regulation by the regulatory college will you be able to find people to volunteer to do the peer assessments. Finally, there is a higher degree of accountability. You know exactly who is responsible for the regulation, you know the people who are responsible, you know the structure of the organization, which is different from the other models where you often don't know exactly who is responsible for what in the regulation mechanism.
Richard, you said earlier that the RHPA colleges do not follow the pure self-regulation model. What are some of the modifications that have been introduced in Ontario?
There have been a number of modifications to ensure that regulatory colleges do serve the public interest and they do so effectively. And one of these modifications is that there are publicly appointed members of the council who are not members of the profession, and they now constitute just under 50% of the council and most committees, so that that perspective is there. Secondly, government insists that it improves the major provisions. So for example, if a regulation is going to be made that has a significant impact on the protection of the public, government has to approve the regulation even though it's made initially by the college council. Another modification is that there's lots of reporting. There's reporting to the minister annually and through requests, and there's reporting to other organizations, as we'll see. And finally, every decision that is made by a college is subject to external review. So there's always somebody who can make sure that the decision was based on good information and that it was reasonable. And we'll talk more about this when we talk about the topic of accountability.
What are some of the implications of the self-regulation model and the social contract on those participating in the regulation of a health profession?
Well, you start off from the proposition that self-regulation is not a certainty. It's not absolute. In fact, in most other countries that used to have self-regulation, like England and Australia, New Zealand, it has often ended for many of the professions in those countries. Government is delegating its role to the college, and the government can at any point remove that power and change the regulatory model. So that has an impact on how colleges do things. And the profession then as a whole, not just the college, but the profession as a whole has to honor the bargain. And so any decision that's made by the college or a committee of the college must be made in the interests of the profession, of the public, and it can't be made solely in the interest of the profession or purely in the self-interest of the organization itself. And so this fundamentally affects one's perspective when one is acting in the college as to how you should make a decision, what kind of decision you should make, and the transparency that is involved in making that decision.
So Richard, you've been using a lot of words that have a loaded meaning. Could you briefly review some of those key terms used in this presentation so we have a common understanding?
Yes, it's true. There's a lot of terms that have special meanings. For example, as you probably know by now, the college is not an educational institution, it's a regulatory body. And that's something that you always have to keep on reinforcing to the public who might not appreciate that. And then the word that we use to describe who members of the profession serve. Are they patients? Are they clients? Are they the consumer or are they a customer? Those are all words that can be used. In this presentation, we'll be referring to mostly patients and clients. And then, who do you call the people who are regulated? Do you call them members? That's the term that's used in the Act. But sometimes people feel that makes it look a little bit like the college as a club. And so they like to use other terms, for example, registrant, or perhaps practitioner. And then, what do you call the body that oversees the college? It's in the Act, it's called the Council. But the Council is defined as the board of directors for the organization. And it doesn't help that there are other entities in the legislation that are called councils and boards, so you have to keep that straight. Another term that's used has different meanings depending on how it's used is a report. So for example, in some places, a report is a report to the minister. In other places, it's a mandatory report that practitioners have to make, for example, if they receive information about sexual abuse of a patient or a client. And then there are reports made by investigators that are a trigger for when the complaints process and discipline process can be used. So you have to look very carefully in the context of that word to understand which meaning of report is being used. Other terms have very, very precise meanings. So an investigation is something that's done in respect of a concern about a practitioner. An assessment is a term typically used in the quality assurance process to look at when one's trying to gather information about a practitioner. An inquiry is a term that's typically used when you're looking at the incapacity or impairment of a practitioner. And then some colleges also have inspection programs that are separate from all three of those. Then there's other terms that have very specific meanings that might not be the meaning that the general public understands. So for example, sexual abuse might suggest to the general public a deliberate exploitative act of a sexual nature towards a patient. But the definition of sexual abuse is much broader than that. And so it could involve things where someone is not actually intending to do anything bad, but they are sexualizing the environment and causing harm to the client or the patient. Then there's a whole bunch of acronyms that you have to get used to. Some of them are in the handbook, and you do need to catch up on them quickly, but you will learn them. For example, the ICRC is the Inquiries, Complaints, and Reports Committees that deals with complaints and other concerns about practitioners. QAC is the Quality Assurance Committee. EHPRO is the Health Profession Appeal and Review Board that hears appeals of decisions made in registration and complaints matters. And then EHPRO is the Health Profession's Regulatory Advisory Council that provides advice to the minister on policy issues.
Thank you, Richard.